right? So now we're going to keep the broadcast going. Please hit the like button. I appreciate you guys. We're going to get into um, Judge Glanville recusal hearing and what he was talking about. So hold on one second. Okay. All right. So this is about, I hope it's a 20-minute clip. And we're going to break it down. We're going to listen to Judge Glanville. Now, this is after all of the escapades that has happened, that we went through, and Tay being killed, okay? Allegedly may having something to do with this YSL trial. I cannot verify it, but you know I'm out here in Atlanta, so my fees is a little bit different, okay? So I get some things, and this is word on the street. Now, what's scary to me is that I think this is going to escalate. And we also allegedly hear that other rappers are involved. Okay. So this is ridiculous. Now let's play this. So as we go through the saga, we're going through a timeline. This is Judge Glanville recusal hearing after the contempt, after all is said has been done, talking all the mess, saying nobody gonna see this. We just gonna keep the trial moving like a freight train. We deny your appeal. I'll make it a order. I deny your motion. I'll make it an order. All that hot mess. And when the Supreme Court knocked it back down to appellate court with that opinion in it, Judge Glanville Tell is stuck behind his stuck between his legs right now. We all see the change of his tone. Let's listen together.
His immunity agreement, Mr. Copeland's, will be court 2.
It was just this very simple thing of like, okay, is my witness.
Nobody want to see that. Hold on.
Who was represented by Mr. Jonathan Melnick and advised of his rights and obligations. During the proceedings on Friday, June the 7th, which will be marked as Courts 3, the transcript of those proceedings, Mr. Copeland invoked his Fifth Amendment privilege and was held in contempt.
Many times, though, let's highlight that. He told them that he was going to plead the Fifth many times. And I want to highlight this because when we get into the ex parte transcript, you're going to see that he had communication with the DA before that ex parte meeting several times and hinted to them that he would be pleading the Fifth.
And that will be Courts 4, Mr. Copeland's order of contempt. Mr. Melnick informed the court that he was not going to be in attendance of any further proceedings as he would be on leave effective 10 June of 2024. The court informed Mr. Melnick that his leave, or had discussions with him that his leave was not proper and that he needed to be in attendance on Monday, June the 10th of 2024 of Mr. Copeland.
This is a timeline. So Mr. Melnick and Ms. Bumpus are together with Woods, okay? Mr. Melnick is the gentleman who you don't see, but originally was in limbo to represent Woody because he represented Woody before. But in this particular hearing, Mr. Melnick was trying to pull himself out because of what was happening to Woody, and he knew he was going to be railroaded, and Mr. Melnick was allegedly going on leave. And this judge literally, through the ex parte, tried to say, I don't care, he's not going on leave. It does not matter. This trial is going to go on. He needs to be here. And then tried to push it on Ms. Bumpus. Okay, this is the clarity of this situation right here for you guys.
Mr. Melnick relayed that attorney Caleb Bumpus would be representing Mr. Copeland. On Monday, June the 10th, before court, Mr. Edward Chamberlain, the court's litigation manager, informed the court that the state wished to have an ex parte meeting with the court. No subject matter of the ex parte meeting was told. The entirety of the ex parte hearing held on the 10th of June of 2024 was taken down by Ms. Christina Weaver, the court's official court reporter. This ex parte hearing was held in chambers starting at 9:10 a.m. Present along with the court were Ms. Caleb Bumpus, attorney or ADA Ms. Adrian Love, Also present were the DA's investigators, Mr. Long and Mr. Hamilton. The ex parte hearing stood in recess from 9:34 to 10:03 a.m. to await Mr. Copeland's arrival. The ex parte hearing resumed with Mr. Copeland present at 10:03 a.m. Also present were Attorney Bumpus, Ms. Hilton, the DA's investigators Long and Hamilton, the court and security personnel, deputies Houston, McPherson, Brown, Sergeant Brown, and Sergeant Hall.
They named, you see how many people were in that room with Woody? And those may have been the same people who were ice grilling him outside over the last couple of days that Still and the other attorneys noticed.
The ex parte hearing stood in recess to allow Mr. Copeland to have a private conversation with Attorney Bumpus from 10:17 a.m. to 11:28 a.m.
I chose St. George's.
And while this is going on, I want to highlight this because I did not play that clip. I want you to go to the attorney's page to watch it. Basically, Ms. Bumpus says, I don't remember talking to him this long. She says she don't remember having this long of a conversation with Woody, because for an hour, you should remember the conversation because you should be giving him some legal advice. So I'm bringing that up because this is the things that the judge is putting on the record. If we're able to see the other hearing in real time, that would be amazing because we're going to see the contradiction between his statements and Ms. Bumpus' statements. And that's why I was a little skeptical with Ms. Bumpus coming out talking so much because she has to face this man. As you see, Mr. Still said specifically, you are now a witness. You in the state are now a witness, and you have to recuse yourself. You have to let another judge listen to this. So they're all going to be in a hearing together, and he's not going to be in that seat. All right.
The ex parte hearing resumed at 11:28 a.m. The ex parte hearing concluded at 11:31 a.m.
Oh my goodness.
The court arrived in courtroom 1C at 11:49. The transcript of those proceedings starting as of 11:49, or when the court presumed that held the proceedings on 10 June in courtroom 1C 2024, that will be marked as courts 5. The proceeding in 1C commenced on the record at 11:52 a.m.
So everything that he did not put on the record on that day, that's what he's trying to put on now. And to me, that's telling me that he knows he's in deep doo-doo. I think he knows he's in deep doo-doo.
A lunch recess was had at 12:51 p.m. The parties returned from lunch, and Mr. Steele informed the court that he had a motion, and that was at 1:46 p.m. In asking then Mr. Steele later that afternoon was held in contempt. However, he was allowed to continue representation of Mr. Williams. The court, in asking Mr. Steele questions of how he received the information that he proffered in open court, was only concerned about the integrity and security of the conversations that were had in chambers, not whether those conversations were the subject of proper ex parte conversations or the sum and substance of what was told him at that time.
So he's highlighting that Still wanted to know why he was not told about the ex parte, not the subject matter totally at that time. That's what he's saying, because you heard that day the judge was basically like, tell me who told you, tell me who told you, basically like, you just stop talking, you know too much. And that was his concern. So just listen to what he's putting on the record.
Jurors Jurors entered the courtroom to resume Mr. Copeland's testimony at 3:39 p.m. The jurors were excused and exited the courtroom at 5:56 p.m. Mr. Copeland was excused and exited the courtroom at 5:58 p.m. The court asked Mr. Steele again whether he received ex parte information, and that would be at 5:59 p.m.
So basically, he's highlighting that he continued the trial while Attorney Steele was held in contempt. They let Steele come back out because at the end of the day, Young Thug was like, he said that that was his primary lawyer and he can't continue the trial, and you're interfering with his right to defend himself. And that's why Steele was able to come back out that day. And he allegedly gave Steele an extension to 5:30 that day to tell me who told you, or you're going to be held in contempt. He tried so many different measures, you know, to try to get him to purge himself, but still stood strong. And at the end, still came back like, listen, two things. Well, one thing. Can I be in the cell with my I'm about to say defendant, with my client? He said, because I have to come to work on Monday and I need to be prepared. That's even showing you a heightened level of case interference by even trying to throw this man in jail on the weekend, knowing that they have to prepare for everything, every motion they want to move forward to, any type of evidence that came in. They have to review all the videos, find the issues, put motions in to get these things taken out. This happened. This is a 24-hour job as a lawyer. That's why I do have respect for honorable lawyers. This shit ain't no joke. So Steele was going to try to get his paperwork in that jail, funky ass jail, mess around and had an asthma attack, and did what he do. Shout out to Steele again. You know I love him. Let's play this.
Mr. Steele's counsel, Ms. Ashley Merchant, and Mr. Alex Susor entered the courtroom. Mr. Steele was held in criminal contempt. That order of that contempt will be marked as Court 6, and the proceedings concluded at 7:41 p.m.
You know why I smile so big, right? Because they said Ashley Merchant. Let's put her on the screen if you don't know who she is. Is another honorable lawyer. Came in there hot. Yeah, no, you know, if I love them, they're going to get represented on here, baby. Hey, go Ashley. Go Ashley. All right, let's move forward.
The court further takes judicial notice of the following statements proffered by Attorney Steele, Brian Steele, in open court upon information and belief stated to the court, which are still unknown. There are 6 assertions that Mr. Steele proffered in front of the court. Those are contained within the transcript of Courts 5, the proceedings that are held on the 10th of June of 2024 in courtroom 1C, which the court's already said will be part of this order.
We have that. We're going to read that next, okay? We're going to read that together.
The first assertion.
We're going to read all of Steele's assertion. You hear what he says, but we're going to read Steele's word for word, okay?
And the transcript bears out exactly what Mr. Steele said, so the court is paraphrasing the 6 assertions that Mr. Steele made. They're more aptly and more eloquently put in the record. The first one involves his concern that
I'm Millie, a content creator, coach, and business owner. If I had to start...
Stop it. You got commercials on yours.
Supposedly in chambers, this honorable court reporter, court at times, district attorney or district attorneys before the DA's office, as well as investigators, sheriff, and deputies, Mr. Copeland and his counsel met together. None of the defense team, to his knowledge, were present. Second assertion he makes is that Mr. Copeland intended to plead the Fifth Amendment.
Yep, he did.
Third assertion is that Mr. Copeland, as a party, was sworn, and Mr. Steele asserted that this particular conversation was, in fact, a critical stage, and that the defendants had the right to be present. The fifth group of assertions involved Mr. Copeland not going to testify. The fifth group of assertions involved what Ms. Attorney Hilton claimed or said to the witness to include the court involving
Yeah.
allegations of coercion and witness intimidation, and that his counsel had the right to be present. And the sixth assertion that was made in open court was that Mr. Copeland admitted to killing Donovan Thomas.
No,
At some point after Mr. Steele was held in contempt by this court in the afternoon of June the 10th, it was brought to the court's attention, not at the court's request, by security personnel that video footage of what occurred outside courtroom 1C shows the interactions between Ms. Bumpus, Mr. Steele, Mr. Adams, and Mr. Sharp.
now we're going to stop right here because I want to highlight, we went into this yesterday, that allegedly Ms. Bumpus said that she was not the first person to talk to them about this. She was the second. And by the time she brought it to their attention, or when she talked to them, she gave them more information, filling them in, as per the interview on the attorney. Now, that was caught on camera. And at the time, all that chaos was going on that day. The judge didn't see all that, didn't know, but he went hunting. He had to go hunting to see what went on all around that court to find that actual clip. That's how much he a monster.
The court in no way sought to investigate any facts of this.
That's a lie. You see what I just said? He said the court, he's trying to put on record that I did not try to investigate any facts or anything. And I just told you, yes, he did. So how did he get that tape that he's putting on the record? Somebody just gave it to him? Mm-hmm.
Involving this footage.
And I'm just saying he's going to use that to hold that against Ms. Bumpus. I just have this feeling, because even though it was not secret, he's going to try to find some ethical issue in what Ms. Bumpus did. The prosecutor is disgusting. And that's what they're going to do. I bet you. That's why if anybody knows Ms. Bumpus, tell her to be quiet and get herself prepared. She needs to get on Steele team, take some classes that Steele took, ask Steele, be her mentor, and get it in. Because I think that Judge Glanville is going to try to throw her under the bus for actually doing this and thinking that she set this off by telling. That's just my opinion.
And only considered it for the security and timeline of events that occurred on June the 10th of 2024. Also, in no way did the court consider any of this footage in holding Mr. Steele in contempt. And as I said, mentioned it only for the purposes of considering the security and breach of information that occurred within the court's chambers.
So he's putting his defense in this record right now for the next court to review, because this is his order he's making. Okay. And he's saying, I just basically got this tape or whatever that he just put on the record for security issues and security breaches. Listen in detail. He's setting up his defense. Ms. Bumpus, you got to listen. I know you're listening. You better get ready to counteract this.
Not for the whether or not that was truthful or not.
It's that time of year again.
We watching somebody video in live time, and I will put this video at the bottom so y'all be able to see. I can't download all of this stuff.
Mr. Steele makes
three. This is actually this is the Paralegal Institute of Washington. Shout out to him. I think he's actually going live too. This is his first time going live, so shout out to him. I'm using just the bits of his clip, and these clips are actually public clips, but he got the right parts. So shout out to him.
Further made three assertions on the 10th of June of 2024. One, he asserted that this was, on behalf of Mr. Williams and similar situated individuals, that this was the court held an improper ex parte meeting. Secondly, that Mr. Copeland was a sworn witness, and this was a critical stage. And Mr. Copeland was a sworn witness. And third, that he argued that this was a critical stage and that he and the others needed to be present at that point in time to pursue the Sixth Amendment rights of defendants in this case. As to Mr. Steele's first assertion of whether or not the court held an improper ex parte meeting or hearing, the court is guided by Judicial Code of Conduct 2.9, which I'll take judicial notice of, which in pertinent part, where circumstances require ex parte communications are authorized for scheduling, administrative purposes, or emergencies that do not deal with the substantive matters or issues, provided that the judge reasonably believes that no party will gain any procedural, substantive, or tactical advantage as a result of the ex parte communication.
Let's stop. What the judge is doing is reading the law. And as he read the law, I want you guys to listen how everything he did is completely opposite. Okay. So one of the requirements that he stated first of ex parte law is that the defendant and the prosecutors and all parties to the case must be aware of it. So there is no gain advantage between any parties. Period. It's not except on this, except on that, or amendment. You got to listen. If there's amendments and things and they say except when this, that, and the third, then that's when it's an exception to that. So just listen.
And the judge makes provisions promptly to notify all parties of the substance of the ex parte communication and gives the parties an opportunity to respond. And in this particular circumstance, the transcript of these proceedings was just prepared and is final by my official court reporter, Ms. Weaver, and all counsel will be, as I said, given an opportunity to, as soon as the court finishes entering this order, it will be e-filed, so everyone will have a chance to take a look at it and use it as they see fit. In this particular, and then the last part of 2.9 before the court goes on, if involves in pertinent part, if a judge inadvertently receives unauthorized ex parte communication bearing upon the substance of the matter, the judge shall make provision promptly to notify all parties of the substance of the communication, provide the parties with a reasonable opportunity to respond. And as I mentioned earlier, I'm going to release the entirety of the transcript to you all to use as you see fit, and before any other further examination of Mr. Copeland.
All right, so you see here, hold on. Let me just pause it. All of that hot sauce that he was popping, all of that hot sauce is totally different now. Before he said, we're going to be giving you bits and pieces of what we feel you should see on the ex parte communication. He was going in the last few days about that and what he was going to do. And now you see, he's going to release the whole transcripts, and that's what we have for you. Now, I'm going to get a little distracted, y'all guys. Don't get mad at me. You see the court reporter, Valerie? I found who the court reporter looks like. It's two characters, but this is the one that the court reporter looked like. She beautiful, though. I'm not being mean, but we're going to have a little moment here, Valerie. You already know. You was like, what is wrong with this court reporter? Don't she look like him? Don't she look like Beavis and Butthead? Am I tripping? Am I tripping? Now, you see, put this on the screen, and then we're going to put the court reporter there. All right. And it's one more person. I'm cracking on the court reporter right now. I do apologize. Let's put her back on the screen. Let's get the proceedings back going. Valerie, tell me, am I off? The court reporter, tell me, am I off? Remember you was asking about this lady. Doesn't she look like him? Don't she look like him? All right, let me cut it out with my crazy self. Sometimes I get sidetracked. I'm like, look at this lady. Look at this lady. But she's amazing. But what I will say with the ex parte transcripts, there are some things that's missing. There's some dash. There's some I know, you know, detail. I'm like, either these people can't speak or the court reporter messed up on some shit. So I'm just going to keep it real, okay? If his mouth was turned upside down, yes, when he closed his mouth, it's kind of like that. But I'm going to show you the other character too. Once I find it, okay, it's a Nickelodeon character. We're going to get to it, okay? All right, let's play this.
Address the issue of the emergency nature of this particular hearing or this particular conference in front of the court. is that this involves the state's concern as to what Mr. Copeland was in fact told by his counsel, Mr. Melnick, and his understanding of the immunity agreement pursuant to 24-5 507.
Now that's talking about competency and his understanding about pleading the fifth. Okay.
And that the conversations that were had in the transcript will bear out that no tactical or other advantage or any testimony that was stated during that particular hearing would be anything other than the court and or the state communicating, along with Ms. Bumpus, his lawyer, who's there the entire time, his witness's understanding of his immunity agreement. In consideration of this emergency nature, the court is taking into account a couple of cases I'll cite for the record. One of them is United States versus Adams, and that's 785 F. 2nd 917, decided in March the 31st of 1986. In pertinent part, presence of the accused. Although an ex parte conference to discuss threats against the witness is proper, district court must ensure that the conference is carefully conducted so no rights of the defendant are threatened. Presence of the accused. Ex parte conference between judge, prosecutor, and government witness to discuss refusal of witness to testify because of his fear of reprisal was not improper, where substance of the inculpatory testimony was never discussed and the entire conference was transcribed.
Sorry, I knew I was mute. So basically, he said that at no point was there any communication about his testimony inside of the case. And there is a little section inside of that ex parte that the Miss Hilton, and I didn't know her name yesterday. I ain't gonna forget today. That's Miss Load 'em up questions, bust 'em up shots. You know, she was driving Woody crazy. Her and Woody was going at it. I wish I had the clip too, just getting sidetracked. Did y'all see the clip where Woody basically told her to get away from him? Because he tried to make it seem like she stink, and she went running because he started coughing, and she went running back, and he was like, wait, get away from me. I'm gonna try to find that clip. Him and her were going through it. Miss Hilton, okay? So let's listen, as he mentioned, that it was no time that basically any testimony was talked about, okay? And ex parte meetings, from my knowledge, is supposed to address outside issues that can affect the court, not the court matter. Issues such as, I can't be here because I have a death in the family, I have cancer, I have this treatment, or I have fear for my life. I got a threatening letter, something else. But everyone needs to know about this ex parte. And usually ex parte meetings are initiated by the person, the witness, not actually the prosecutors or the judge. Okay, just to give you a little bit more insight into ex parte. Okay, we almost done with this clip.
And in Adams, the appellants contended the ex parte conference was improper and it violated their due process right to a fundamentally fair trial. We agree with appellants that ex parte conferences should occur, but rarely, especially in criminal cases. This does not mean, however, that such conferences are unconstitutional. Indeed, some situations, the trial judge may find an ex parte conference necessary. Cite.
I've helped non-tech people get into tech and land multiple six-figure cybersecurity jobs. And
La Chapelle, and that's LACHAPPELL versus Moran at 699 F. 2nd 560. It's a First Circuit case from 1983, where the court cites, in the exercise of the court's residual power to ensure a just trial, protect jurors and witnesses, a judge may, in rare circumstances, feel it necessary to confer with a juror or witness on the record, but outside the presence of others, including the defendant. One such conference may be where a juror witness, having been threatened, wished to speak with a judge privately about a threat.
He's giving examples in his order. He's filling all of this up with fluffer, y'all. Just fluffer. For real. But listen, he's reading the law.
Witness may not feel free to discuss any threats in presence of the defendant or even counsel for the defendant. We agree that the First Circuit, the ex parte conference is appropriate in that situation. They see United States versus Arroyo, and it's ANGULA. It's at 580 F second, 1137, pinpoint 1142, 1142, and 1141, 1142, Second Circuit case. Exclusion of certain defendants and counsel from in-camera proceedings permissible in multiple defendant trial, where certain defendants had cooperated with government and received death threats. And they've got a citation for that being 439 U.S. 913. Although an ex parte conference discussed threats against witnesses proper, the district court must ensure that the conference is carefully conducted so no rights of the defendant are threatened. In this case, the court followed procedures to ensure the conference was fair. First, at no time was the substance of Pooley's inculpatory testimony discussed. And second, the entire conference was transcribed. And that's United States versus Watchmaker at 761 F second, 1149, 1985. Ex parte conference with frightened juror properly were transcribed and the judge's comments carefully framed. This court goes on to say in Adams, two aspects of this conference, however, disturbing. First, when the prosecutor began to impress upon the witness the distinction between being paid for testimony and afforded protection, the trial.
He's giving more examples. And the reason why I'm shaking my head, because every example he gives literally is heightening more of the fact that he wasn't supposed to do what he did and that it's supposed to be transparent. He's not giving any law actually to support what he did. He's giving law to the defense. I don't know what he's doing here. Doesn't make sense. Any person who researched law knows something's wrong with him.
Court should have called the conference to a close.
And this is what he said. Okay, just listen. I was talking, but we're going to listen to that again. If anything that is critical that can cause any issues to the court case, i.e. something that has to be put out on Front Street in front of and put on the record within the trial, the judge is supposed to stop the ex parte meeting and bring it into the front. And this is what he's talking about.
Witness the distinction between being paid for testimony and afforded protection. The trial court should have called the conference to a close. The portion of the record quoted above indicates an attempt by the prosecutor to coach the witness on how to answer questions about inducements from his testimony. The court had already learned all it needed concerning the witness's fears and the prosecutor's plans for protection, there being no reason to participate in such coaching. Second problem occurred where Pooley took the stand. Defense counsel inquired about what inducements had been given for Pooley's testimony, and the prosecutor and Pooley both indicated the promise was the prosecutor would seek to enroll Pooley in witness protection program if he were in fear of his life. Neither related to the prosecutor's pledge to seek immediate protection for Pooley should it be necessary. The exchange occurred before the court, and the court should have made sure that the inducements made as in the ex parte conference were completely and precisely disclosed.
I'm gonna stop here. You see why I'm making my face? This hurts me because Judge Glanville couldn't have read this before he got there. Somebody had to write this up, trick the paper, switch it, because everything he's saying for the reasons to actually stop an ex parte and the things that he was supposed to do when Woody felt like his life was in danger, as I mentioned to you yesterday. Witness protection, start moving forward with other matters, especially when someone is in an ex parte meeting, disclosing to both sides and within what he's talking about, according to the law, and they were supposed to move forward and stop the proceedings and do whatever they need to do to protect the witness. Oh my God. He also talks about coasting or coercion between any side and the witness. And you're going to hear specifically when we read the ex parte that Miss Hilton and the judge was coasting him, was kind of pushing him into, hey, don't plead the fifth. You're going to go to jail. You're going to go to jail. You're going to go to jail. It's Father's Day. It's this. Somebody's birthday. They was using everything they can to stop Woody for pleading the fifth again when he went to court after they held him. I'm just giving you a heads up. This is so funny to me. I'm like, no way the judge wrote this and read this shit. He gave everything to the other side. Welcome to Urban Politics, where you're here with Grace Levi, your hood legal nursing consultant translator. This is what I do. And I be amused in the background like, yo, did this person do this? Oh my God. Judge Glanville is setting himself up to be recused. He gave them everything. And I'm looking at this, keep going. I can't believe it.
Similarly, in this matter,
Crazy.
um,
I'm sorry.
To me is
literally
basically freedom.
I don't. What the hell wrong with him? He lost his mind. He ain't not. Now he went from being. Hey, hold on. He went from being extreme, right, to extreme until now telling on himself and giving the defense something to work with. What is wrong with this? This is the post-traumatic stress syndrome kicking in. Oh.
the only thing discussed between the state counsel for Mr. Copeland and this court were the understanding of his immunity agreement. There were no other testimonial statements made by in terms of what Mr. Copeland planned to testify to that were induced or sought by the court. And the transcript in its totality will bear that out. You can have a look at that. The court's also considered Bruner versus the state. That's 302 Georgia at 6, and this relates to the right to be present and what is defined as a critical stage and under the Sixth Amendment.
I'm gonna try to push this a little faster. We're almost done with this clip.
Bruner contends that he was denied the right under the Georgia Constitution to be present at certain critical stages of his trial proceedings. Embodied within the constitutional right of the courts to a criminal defendant's right to be present, see and hear all the proceedings which were had against him on trial before the court. Ward versus the state, 288 Georgia 641, pinpoint 645. Violations of this due process right are presumed prejudicial, absent a waiver by defendant requiring a trial. However, there were no violation of Bruner's right to be present. The right to be present attaches to any stage of a criminal proceeding that is critical to its outcome if the defendant's presence would contribute to the fairness of the procedure. And that's Huff versus the state, 274 Georgia 110, pinpoint 111. Thus, a critical stage of a criminal proceeding is defined as one in which the defendant's rights may be lost, defense is waived, privilege is claimed or waived, or one in which the outcome of the case is substantially affected in some other way. And in this particular case, the court is of the opinion, basing on looking at the case law, that
and again, this he gives more to the defense, and he says that in any time he's supposed to stop the ex parte meeting if a witness was losing any rights, okay, if there was any situation that the witness was losing their rights, and it was, they set Woody up, okay. Through the transcript, you're going to see, we're going to highlight Woody talked to these DA several times before this. He asked them in different ways, well, if I plead the fifth, do I got to do this? I'm going to be locked up. If I plead the fifth, I'm going to be locked up. Is this going to happen? He kept asking it in different ways at different times, and even just before they met. And I'm going to tell you, I felt like where they met at was dangerous. It was a signal to the people out there in the hood what was going on. When we get to that, I want to tell you. But even at that time they met, Woody was suggesting that he was going to plead the fifth. It was what it was. And then he got there on Friday, and they present him with immunity and say, hey, we present you immunity. Whatever you say is not going to go against you, this, that, and the third. But you got to understand, this is on a state level. The immunity they're giving him is on a state level. It's not on a federal level. Okay. So if Woody was to testify to anything, two factors. It's not protection on a federal level. If Woody was to testify anything that will be able to be substantiated with evidence, there is a possibility that the state could pick up charges, and that will be on them if they choose to. And that was what they were asking in the ex parte meeting too. And they were like, well, we won't do that. They kept saying, we won't do that. We just want you to tell the truth. So I wanted to break that down, how Woody rights was actually taken away through the ex parte, because I'm giving y'all more of the ex parte, just leaking it to you guys. And he did not stop the proceeding. Judge Glanville gave his defense, everything. And I think he wants to retire. That's my opinion. He got to want to retire right now. The game is over. It is. The game is over.
That this was a proper ex parte meeting pursuant to 2.2, Rule 2.9, as well as the no party gained any tactical advantage, and that
Cali Express touts itself as the world's first fully autonomous restaurant to the road.
The proceedings as a whole are released to will be in the terms of the transcript. So what was said can readily be seen and utilized by the defendants. Okay, and the court lastly took into consideration Talton versus the state. That's 368 Georgia Appeals at 313, and that involves a Sixth Amendment critical stage definition that was decided June the 21st of 2023. And in pertinent part, in many instances, remand will be necessary when the right to be present claim under the Georgia Constitution is raised for the first time on appeal from criminal conviction. So Mr. Seals raised this at the appropriate time, and the court is in fact considering it. And the Georgia Constitution guarantees criminal defendant to be present, see, and hear all proceedings in which are against him on trial before the court. Criminal defendant's right to be present under the Georgia Constitution attaches to any stage of the criminal proceeding, which is critical to its outcome if the defendant's presence would contribute to the fairness of the procedure, but the right does not extend to situations where a defendant's presence would be useless or benefit but shadow. And under the Georgia Constitution, defendant who is represented by counsel need not be present for portions of the trial that involve questions of law and consist of essentially legal argument about which the defendant presumably has no knowledge.
That's why it should be the lawyer there with the witness, because if there's legal genre that's being talked, that's why they were trying to make Ms. Bumpus Woody's lawyer, and Ms. Bumpus like, I'm fired, I don't have nothing to do with this. That ex parte, he needed representation there. They were pushing this to work the way they wanted it to work.
It is well settled under the Georgia Constitution, guarantees the criminal defendant the right to be present and see, hear all the proceedings in which are had against him or trial before the court. It's Prickett versus the state, 314 Georgia, 435 at 441 pinpoint. This right attaches to any stage of the criminal proceeding that is critical to the outcome of if the defendant's presence would be contribute to the fairness of the procedure. But the right does not extend to situations where the defendant's presence would be useless or benefit or shadow.
All right, we're going to stop right there. All right, so we listened to a lot of it. You hear his tone. What I'm going to do is just read a 2-page excerpt of Glanville actual first order of contempt. You hear Glanville's voice and how he's talking now and how calm, cool, collective he is, and basically how he set his own self up, telling on himself. That's why I like this, and I hope you guys are learning. That's why we're taking our time and going through this, because you can hear the bleeding out of Glanville and how he's going to lose his job, possibly. Now, what I want to highlight just before we get into his hot mess, I want y'all to understand the Sixth Amendment real quick, okay? Some of the aspects of the Sixth Amendment and what they were talking about, and that's the right to a fair trial, okay? So the Sixth Amendment has a few parts to it, and that is rights to secure a speedy trial, a public trial, an impartial trial, impartiality, meaning that you're not guilty just because, okay? And that's some of Steele's arguments many a time. To ventures of juries to be able to select juries, you and them to go back and forth and say, hey, this one in, this one out. A fair sentencing, notice of the accusations so they can get prepared for their defense. And that's why notice of all proceedings, the right and ability for confrontation for you, the person being charged, to actually go against the person who's accusing you, i.e., this is Andrew Holmes' right under the Sixth Amendment for confrontation. And what I mean is that if they bring proceedings to him, he should have the right to cross-examine the witness or the person coming against him. And if a man is honorable and telling the truth, the right to confrontation is one of the best parts of waking up in a case under the Constitution to stand up for yourself. I just had to highlight that so we can put that in perspective of, applying law to the situations we're talking about. The compulsory process, basically the administrative process, needs to be favorable and just. They can't just be running through things like Glanville was doing, as far as when he didn't put the first order in and just basically say, motion denied. Nope, you can't recuse me. That's what he did not do. He directly went against the compulsory process. Everybody has the right to assistance to counsel. That's why they were trying to force Woody to have Miss Bumpus in the room with him, trying to force Mr. McCallum to be his lawyer. Okay. Also have the rights to self-representation, lastly. And that is an example of what Jedediah did when he was in court against BB. Okay. And that's why the judge respected the way Jedediah actually stood up for himself and represented himself, because you as the person can stand up for yourself pro se. All right. So I just wanted to throw that little Sixth Amendment teaching to you, apply it to your life. Now, let's listen to all this hot mess that Glanville was talking when he was saying, still, you're going to jail. No matter what you say, you better tell who told you that. All right. That was all the hot sauce that man was talking that day. So let's just read this two-page filing of order of contempt and incarceration for Brian Steele. This is on 6/10, the day that they keep referring. During the proceeding in this above style case on the afternoon of June 10th, 2024, one of the two representatives for defendant Jeffrey Williams, Brian Steele, took the podium and stated that the court had been informed of an ex parte communication which took place in the court's chambers that morning. The only parties present for the ex parte meeting were the court officers, court reporter, representatives of the state witness, Mr. Keith Copeland, and counsel for Copeland. In addition, what he missed out in this order was the 6 police and sheriff deputies that was there and the 2 detectives that was there, that you will hear Ms. Bumpus verify in her interview on the attorney page. There were like 12 or 13 of them in there. Okay. So he left that out of his order. In addition, the court's serious concern, and this is Glanville order, serious concern with how this information wasn't properly disclosed to the defense counsel. Mr. Steele was made several claims regarding the sum and substance of the communication that the court found troubling. The court has told Mr. Steele multiple times that he needs to tell the court how he came into this information. The court has explicitly warned Mr. Steele that he has faced contempt charges in court should he not comply. The court finds Mr. Steele has repeatedly refused to follow the court's order. Every court has the power to compel obedience to its order and to control the conduct of the person conducted within the judicial process. He controls, you be obedient, and that is the law that he chose. Okay? Not referencing anything about ex parte meetings, his right to do so, the blah, blah, blah. Now, one who disobeys an order or command of the court may be found in criminal contempt. Violating a court order the order should inform him in defiant terms as to the duties where imposed upon him, and command must therefore be expressed rather than implied. So we're going to tell you that I'm going to lock your ass up. It ain't going to be just expressed. It's going to be implied. According to its honorable order, according, it is hereby ordered that pursuant to the court authority under OCGA 15-1-3, the court holds Mr. Steele in direct criminal contempt for failure to comply with this order. And the order is, you tell me what I say because you in my court. I don't care. It is further ordered that Mr. Steele shall be taken into custody of the Fulton County Sheriff and incarcerated at Fulton County Jail for no more than 20 days for this contempt. With those 20 days consisting of every weekend for the next 10 weeks. That is literally 2.5 months. Mr. Steele is to report to the Fulton County Jail, Rice Street, Atlanta, Georgia, at 7 p.m. on Friday. And we will release at 7 p.m. on Sunday, literally taking up his whole weekend, putting him in that hellhole of a jail. That was the hot sauce that the judge was speaking before it got kicked down from the Supreme Court and that opinion come down to with it. Does it make sense? All right. So now we're going to get a little bit into, do y'all want to hear a motion to disqualify and recuse the judge? I do have that document that was filed 7 days later by Mr. Steele. And we could get into it just a little bit because he talks about some of the things that was with Mr. Steele concerned, and we could just highlight some of those what Mr. Steele has to say. Okay, I'm gonna bring it to you. Let's get to the documents. So you get a 3-for-1 today. You get 3 different readings today. You like me better? What you're doing? This thing started moving. So Miss Valerie, it's better for me to read it or to get that voice on it. I'm just gonna read it because I got more energy today. Okay. So let's get to this one. This is actually the motion to disqualify, recuse Judge Glanville from all further dealings in the above referred case. Motion for mistrial, which was also goad by the improper conduct committed in ascertained by the court and prosecution. Let's go. Let's see what Mr. Steele got to say. We're going to try to run through this a little bit fast. On Monday, June 10th, 2024, within 5 days of the filing of this timely motion, this court, along with the prosecution, engaged in an unlawful, improper ex parte meeting, among others, a sworn witness, Keith Copeland, for whom the order was used immunity had been issued on Friday, the 7th, 2024. So that day when he showed up on Friday, they gave him that. No notice of the ex parte meeting was provided to the attorney for any of the criminal accusations in the case. In fact, the accusation in the accused and their counsel were in the dark that the Star Chamber meeting occurred. Mr. Copeland had previously been called to testify on Friday, June 7th, 2024, asserting that the Fifth Amendment privilege in an open court in front of the jury and was held in contempt and similarly incarcerated until such time as he agreed to testify pursuant to the grant of immunity. So this is what he's highlighting. And this is what I told you. They literally forced him to testify, to say something by, I'm going to help you. We're going to grant you immunity. And that was his new stance. And that's basically put him in jeopardy to be locked up 2 ways, through pleading the fifth and through perjury. The prosecutors are monsters. Miss Ain't Love, they know what the hell they doing, okay? So Judge Glanville and the prosecutors essentially admitted by silence and by some statement on open court that the ex parte meeting occurred on the morning of June 10th, only after undersigned counsel revealed undersigned counsel revealed based upon information and belief that this impressionable meeting occurred. Now, this could have been Mr. Malikan. I'm saying his name wrong. It could have been him, okay? Who was the first person to tell. We still don't know. We'll find out at that hearing. So at the earliest opportunity on the afternoon of June 10th, the court was informed based upon information and belief that the ex parte meeting with the sworn witness Keith Copeland and the prosecutors occurred earlier that day. That the witness had made factual omissions and statements were made to the witness by the court and the prosecutor acting in coercion. About the amount of time Mr. Copeland could be held in custody. The court denied the undersigned counsel request for the transcript in the ex parte meeting and denied timely motions for mistrial based upon the improper and illegal ex parte meeting, which violated Williams' a constitution and statutory right, including the right to due process, a fair trial, a fair tribunal, ethical procedures, and the right to be present at every critical stage of the proceeding. So he's talking about the rights of Jeffrey Williams being taken away because he didn't know that this was going on. Okay. Uniform Superior Court Rule 4.1 Georgia Code Judicial Conduct 2.9 rules govern ex parte communication. So this is what they go into, what we talk about ex parte communication and what it's supposed to be. Generally prohibits ex parte communications. Under this, he's highlighting a section. Generally prohibits ex parte communication except as authorized by the law or by rules. Judge shall neither initiate nor consider ex parte communication by interest parties or their attorney consider a pending or impending procedure. So two things: the judge shouldn't initiate it. As I told you, the witness is supposed to initiate it, and it should not have nothing to do with in consideration of the rulings, the judge's ruling. Okay, like for instance, somebody's life is on the line. That has nothing to do with the case of the judge's ruling. Okay, just to give you that's kind of like a third level connection. And the judge even talked about that. So it made me mad because the judge, I think he changed his tone, honestly, because he knows somebody got killed. And this was something in the ex parte that was kind of brought up. He brought it up. That basically, I will read it to you. He brought it up in a way. So ex parte hearings are only authorized in the case that extraordinary matters such as temporary restraining orders or temporary injunctions and other judicial hearings. Both parties should be notified if the hearing with the opportunity to attend and voice any objections that may be properly registered. So he put the law, he put the case up there. Now, the court violated USCR 4.1 in the Georgia Code of Judicial Conduct 2.9. The court has joined the prosecution team and is based against Williams and favorable to the prosecution as objective determination on June 10th, as well as through the proceedings of the case. Because they've been saying it's like, look, you literally work with her. Like, this is bias. This is bias. We're watching it, and we've been saying it too, and we all don't know law. People were like, listen, this ain't right. This is crazy. So the trial court rejects undersigned counsel's subjective request for information about the unlawful ex parte, and the court denies undersigned counsel motion for mistrial. So that's what you heard before in our opening, where he was like, nope, you ain't getting this. You're getting parts of this, and it's not going to be a mistrial. Moving forward, so the court stunningly demands to know how undersigned counsel came into the possession of the information about the ex parte meeting. The prosecutor stunningly sat mute and permitted this injustice to occur and for the court to attempt to intimidate the counsel. Later, Love and lawyer currently employed with the Fulton County District Attorney argued that ex parte hearings with witness Copeland was ethical, just and proper. The other prosecutors still remain mute. And we're talking about Miss Hilton sitting there and shit like, Underside counsel declined to join the authentic in ignoring rules and ethical provisions and denied to provide information requested by the court. Relying on the state bar rules of professional conduct 1.6, which states this. So they talked about the professional bar rules that pertains to that of gaining information. Let's move on. The court ignored the ethical rules relied upon and continue to demand undesigned counsel to reveal the source of the information. He like, listen, I don't care. Who told you? Who told you? Claiming the way that the undesigned counsel obtained the information was somehow unlawful, and basically accused undesigned counsel of recording of the potential acquiring of the information. He said, yeah, either you were in there, you had a recording, he was blaming it on Still too. In response to this, and that put Still license on the line. Okay, that put Mr. Still's license on the line. Now let's continue. The court is so biased against undesigned counsel. He like, not only against my witness, the counsel, and Mr. Williams, the court ignored all law and pursued contempt penalties to attempt to intimidate undesigned counsel, to violate the law and the actors in order to continue to help the prosecution convict Mr. Williams. Okay, now this is the one that was sent up to the Supreme Court, what we're reading. Okay, the court issued a written order of contempt and incarceration for Brian Still, imposed a maximum sentence of 20 days, what we just read to you. The Supreme Court of Georgia has granted writ of I'm saying it wrong. I'm going to assert a writ of cert. I'm just going to say it. The breaking down the writ of cert to address the appeal of the contempt order, and has granted undesigned counsel to supersede the bond. So basically, the Superior Court took it so Mr. Still wouldn't go to jail real quick, and then they threw it down so it could be handled in the court. That's why the Superior Court pulled it, because it was no telling when the appellate court would have pulled it and who would have pulled it, because of the situation involving Fulton County and its biasness. Okay, the court violated the law by failing its duty to recuse. Hold on a second. To recuse pending over the contempt charge. So at this point, he's like, just back up. Let's stop this trial. Let's see. This is what we putting up. Let's see about the contempt charge. And you saw what happened. The judge kept going from 3 to 5 o'clock, still asking witty questions that day. In such proceedings where the announcement of punishment is delayed, where the continuous conduct for directed towards the judge, and where the judge reacted to the conduct in such a manner as to become involved in a controversy, the judge may give the attorney notice of specific charge, but the hearing, included the attorney opportunity to hear, must be conducted by another judge. So he basically said that the judge just looked at what he was saying and threw it out and didn't follow the law. Okay. And then according to 274 Georgia, in Schoolcraft case, this is where he was supposed to give it to another judge, okay, to see that motion that they put in for recusal. Okay, so then here the court involved himself in the proceeding by joining the prosecution team and conducting an ex parte meeting that violated Mr. Williams' right. This created a conflict of interest for the court because its own unethical conduct is questioned and at the heart of the issue. The court then compounded its abuse of power by proceeding over the very contempt hearing where its own rule violation prompted the controversy. And that's what he was saying. The judge said, "Nah, I'll hear it. Nope, let's go. Let's move on." So the court should have recused and allowed the contempt proceeding to be held by a separate court. Furthering, the prosecution sat there mute and permitted the court to attempt to interrogate and intimidate another member of the bar who reportedly violated the law, as also promoted the court wrongful conduct by asserting the ex parte meeting was improper. And that was, I believe that was Still partner. And it was another lawyer that tried to bring that up. It was 2 more. And he was like, get out of here. I already know. Motion denied. Shut up. Sit down. You don't want problems. I didn't even show y'all that clip. This is what he was saying. You don't want problems. All right. And this was the judge. The court denied Mr. Williams and undesigned counsel their due process, right, as undesigned counsel has the right to adequate notice and to be heard, and to call witness and to hear and to request the counsel for the entirety of the contempt proceedings. And Williams had the right to learn of all the facts, circumstances, and the critical stages of the proceedings that occurred in his absence of the ex parte. So two things happen. This is when you have Miss Merchant coming, Miss Ashley Merchant, her role in there, where basically she told the judge, you didn't have a hearing. You held him contempt. There was no pre-hearing. You did not give him a chance to get an attorney. We here for it. You remember that's what Miss Merchant was talking about. And this is how it's restated in the disqualification motion that's put together by Steele 7 days after what we just read. All right. So the court abuses authority by holding undersigned counsel in contempt by refusing to divulge privileged information for the protection of Williams. Constitutional rights and due process, right to a fair tribunal, right to a trial, right to the presence of effective counsel. And what amendment is that, y'all? The Sixth Amendment. Okay. Just to remember. This court refuses to acknowledge the rights and the protections that was created under the Fair Tribunal based upon Mr. Williams and his counsel in favoritism of the prosecution. Motion to disqualify recusal Judge Glanville is timely filed in the Uniform Superior Court. That is one of the proceedings for that. The recording also reveals numerous instances during the trial when the judge behavior appears to be biased against Mr. Williams, counsel parties in favor of the state. Millhouse versus State. This was an example of it, some case law. Now, he goes on to say, I'm trying to move out of this abbreviation. The record reveals other instances too, when the trial court wrongly battered counsel in front of the jury. After the numerous such incident, Mr. Williams' counsel out of the jury presence moved from the trial judge recusal and sought a mistrial on grounds that the judge has showed a lack of objective, had displayed bias against Mr. Williams and his counsel. That was another time in December where we showed you yesterday that he was like, yo, you literally calling me out for no reason. All I'm trying to tell you that I want to hear something on this tape or to be addressed. And he was taking it to the left, telling him he wasn't prepared. And he said that in front of the jurors, but didn't want to correct it. So this is where Steele is showing the continuance of bias. And that is just one damn incident. Okay. The Code of Judicial Conduct provides the judges such disqualifying themselves in the proceeding in which their impartiality might be reasonably questioned, including but not limited to the instance where the judge has personal bias, prejudice, concern a party or party's lawyer. And it showed all through it. Within the context of this required that words should mean shall. The same Supreme Court is mindful of the extraordinary pressure attached to criminal trials in this magnitude. So he's like, listen, words mean everything and reputation mean everything. And this pressure in this trial. And on one hand, defense counsel is obligated to vigorously defend his clients against all charges brought to the state. Likewise, prosecutors must effectively and ethically present the state case to the jury. You can't just go out there willy-nilly, and that's what's expected of the judge. And at the same time, and this is what he's going to add, that's what I know still, and at the same time, the trial judge is charged with ensuring that the rules of evidence procedures are followed and that the procedures are both orderly, ethical, and fair. When there's several instances came together in the courtroom during trial, disagreements between the bench and the bar are to be expected. The instance discussed above and in attached Exhibit B, so he gave some exhibits with this, joint affidavits, however, represents more than mere friction between the zealous counsel and the diligent jurist, okay? The judge conduct and discussed above in hearing create an impression that the honorability and the inclination of bias against William and his counsel and partiality towards the prosecution are therefore not in. Higher court needs not decide whether such bias and impartiality actually exists because judges are ethically bound to disqualify themselves whenever there is an partiality might reasonably be questioned. Just might, not that it is questioned, might include an instance where the judge behavior could be indicated that he has personal bias or prejudice concerning a part of the party or lawyer. As explained, the trial judge in this case participated in ex parte communication with the prosecutor in which he assisted the case and influenced a witness to testify against Mr. Williams. These actions raised reasonable questions concerning judge partiality and bias. Because the trial judge impartiality is reasonably questioned, it is error to deny Mr. Williams' motion for recusal, according to John versus State. Do you want me to keep reading this, guys, or y'all want me to get into the actual the ex parte reading? I can keep going, but this is actually Still's motion for recusal. He's putting everything on a record. You already know what's been going on with the judge. Let me see if it's anything that you want me to keep going? Which one? Say yes. You want me to keep reading this or move on to the next one? Give me in the comments, okay? Until then, I'm just going to read a little bit more. Georgia courts has followed this demand for recusal when the judge become embroidered in controversy. You see how I said embroidered? That's my Jersey accent. All right, in controversy. Due to procedure requirement, now he read the law. This is in Berger. Also in Adams, we're not going to read that law to you right now. Second, due process require recusal of the judge when the judge takes a role in the process, the accusatory process, and that's what he did during the ex parte meeting. Okay, and this is found in another case law that he says Murchison, that he highlights here. He gives the excerpt from there. Importantly, a trial judge has the duty to recuse himself from the proceedings in which the judge impartially might reasonably questions, include instances where the judge has a personal bias or personal bias, prejudice concerning the party. We read that. Yes, finish that one first, then move on to conclusion. Okay, cool. So he restated that recusal is objectively required when the judge serves both as the accuser and the adjudicator in the case. So he's giving case law there, where he's like, hey, basically you're playing both roles. And that's William versus Pennsylvania. He goes into say, in the case at the, okay, that's about the, because I'm not going to talk about those cases because it'll throw you off because those cases be remarkably different. But when we go into case law, if y'all ever want me to, I can explain how you can incorporate case law in a different case, okay? But now, this court has failed to follow the lawful path. Instead, the court has usefully become the prosecutor, judge, grand jury, bias, partial, potential sentencer, and thus must be removed from this case in tutu. Okay. On the motion to disqualify, it is the duty of the judge to pass only the legal sufficiency of the facts allegated and to ask whether these facts support a charge or base the prejudice. So when he put that motion into recuse several times, the judge is not looking for basically to have everything as evidence. He's just looking for it to be structurized right, that it is some facts behind it, and that he that will make him move that motion forward. And the judge know that everything he put in the motion was fact findable. The ex parte meeting, the bullying, the intimidation, all of that, that's on its face facts. Okay. So the test is whether, assuming that the truth of the facts alleged in the attached affidavits is reasonable, person will conclude bias exists on the part of the judge. And we see any reasonable person that's what makes the law. Law is based on what the reasonable person would assume. It can't be based on what you want it to be. It's what everyone in this area would assume. I.e., example, if you leave something down on the ground and you leave it for 2 days, according to the law, the most reasonable person would assume, according to the law, it's abandonment. But most reasonable persons would assume you abandoned it. You left it for 2 days. Now, if somebody picked that up and then you come back like, that's mine, because they're using it then that person may have a fight for abandonment, for you basically abandonment. Does that make sense? And that falls under the guise of any reasonable person, us being the citizens would assume that this is thereof. That's how law should be based. Okay, does that make sense? And what we can see, every reasonable person who watched this damn trial, even the grandmas, grandpas, babies, like, what is going on here? What's wrong with this judge? Okay, so we're just going to read this last paragraph because this is a 27-page document. I'm not going to read it all because we got to get to the 50-page document, but I want to get through. I got through most of it. The court conducts raised a strong finding that he has become personally embroiled in the case. It is clear, even the casual observer, that the court involvement in the controversy requires that the court disqualify, recuse, remove from all further proceeding in the above reference case. And another judge who will exercise the power to the judicial branch with a partiality, clarity, and fairness must be appointed to this case. Downey versus Palmer. Okay. Now, what we're going to do is stop right there, and we're going to keep things a little bit spicy, because now we're going to get a word from one of our other favorite lawyers that's going to bring us into the ex parte reading, okay? And we're going to hear from Lawyers for Workers again. He had an update 19 hours ago. New judge, a new motion concerning recusal in YSL RICO case. The YSL RICO trials involves rapper YSL thugs. Hit another twist for the week. Let's put it on the screen. Shout out to Lawyers for Workers. Please go to his Instagram page, okay? He was going to go on YouTube, but he just never did it. You know, like some people can't really get into YouTube. I think he tried it, but not. But Instagram is his page, and I appreciate Lawyer for Workers, so check him out. All right, let's play this.
Update in the YSL case. A new judge has been assigned. Let's show you her picture. Judge Rachel Krause will be deciding 3 separate motions, each motion asking Judge Glanville to be removed from the case. Now, initially, Judge Glanville had rejected these motions, and then he said, wait a second, it's not right. I'm not the one who's supposed to decide these motions. It has to go to another judge. This new judge has ordered that the government has to respond to the motions by, get this, Monday, July 8th. So they'll be working over the July 4th holiday. Another very interesting development. One of the defendants has filed a motion asking the new judge, Judge Krause, to recuse herself. They cite case law from the state of Georgia, arguing that when one judge is deciding whether another judge can stay on, those 2 judges should not be from the same court. In this case, they're both Fulton County Superior Court judges. What the motion from the defendant is arguing is Judge Krause should recuse herself, and send this to a judge in another county, not Fulton County. And we'll see what happens. Definitely by Monday, you're going to get a response from the government. And sometime next week, hopefully we'll hear whether Judge Krause is going to decide this or whether she's going to step aside and send it to another county. Update in the YSL case.
You hear it. We're waiting to hear if another judge from another county is going to see this actual recusal hearing and continue down this escapade, and possibly we get another judge on this court when this happened to Glanville. Okay, what we're going to take is a few minutes intermission because we are two hours in. We have an hour and 15-minute read of the ex parte reading. Yes, you're going to be with Grace Levi for this 4th of July. But until then, we're going to put this on the screen because you know what's about to happen. What's about to happen to Glanville? Tell me what's about to happen to Judge Glanville. Let's put it on the screen.
Why are you detaining me? You about to lose your job. You about to lose your job. Get this dance. You about to lose your job because you are detaining me for nothing. You about to lose your job. You about to lose your job. Get this dance. You about to lose your job. I'm Martinez. You about to lose your job. Get this dance. You about to lose your job. Get this dance. You about to lose your job because you are detaining me for nothing. You about to lose your job. Get this dance. You about to lose your job. Get this dance. You about to lose your job. beat. You about to lose your job in this day. You about to lose your job in this day. You about to lose your job. Is this shit worth you losing your job? Cause you bought to. Cause you ain't got no reason.
Yeah, Jamaicans, true Israelites. We love to see the wake up in our place. Cause we, remember, it's not Jesus gonna come back, it's Yeshua. True Israelites, yard people.